Lubega Yusufu Waswa Hussein Sali Muzamiru Chewali Abubeka Chisalita Ahmed Kato Hussein Miro Bukenya Ismail Buvumbo Musa Abbas and Hajaran Nakandi are the accused persons in the murder case of Susan Magara, the case before Judge Alex Ajij Makai. When the trial resumed for hearing at High Court Criminal Division in Kampala, all the accused persons, through an oral application to court by the accused Sali Muzamiru, asked Judge Alex Ajij to recuse himself in this case.
Oweekitiibwa omulamuzi okuva etwatandika okutambula kooti eno nze nga ngoberera ebitambula mu kooti eno naye nga ngenza okutunuulira ebitambulira mu kooti eno nga birimu ebirumira bingi so n'obuwembeefu obw'ekitalo Oweekitiibwa omulamuzi nga nsaba obeere ng'ova mu musango guno nga nsaba Oweekitiibwa omulamuzi okubeera nga ova mu musango guno kuba nsuubira okubeera nga sigenda kufunamu bwenkanya. Ensonga ensooka Oweekitiibwa omulamuzi okusinziira aba witnesses abazze bajja mu kooti muno bazze nga ababuuzi b'ebibuuzo bakkanso baffe naye bwe batuuka mu kiseera ekyo babuuza ebibuuzo waliwo ebikugirwa bakkanso okubeera nga balemererwa okuweebwa chance okubuuza bye bateekeddwa okubuuza ate nga biba bigasanga nze omuwawaabirwa bwe babuuza ebibuuzo ebimu baziizibwa okubeera nga babuuza abajuliza ebibuuzo ebibadde bateekeddwa okubabuuza era ne wavaawo n'okukayana wakati wa kanso ne ba state ekiraga nti waliwo ebimu bye batagenda nti bwe batuuka okubuuza ebibuuzo ebimu baziyizaako kubibuuza abajulizi bye badde balina okubuuza nekindaga nti waliwo sayidi ewulirizibwa n'etawulirizibwa.
Sali also accused the trial judge for being biased by not allowing the defense legal team to fully cross-examine the witnesses in this matter.
Nabeera nga ndoopa ensonga yange okubeera nga natulugunyizibwa okuva olunaku lwe bankwata okutuuka olunaku lwe natwalibwa mu kooti. Kutuusa olwaleero siwulirizibwanga oba simanyi sibagendera kulaba oba natulugunyizibwa wamu ne bannange oba situlugunyizibwanga. Era ku nsonga endala nali mu kooti eno bakanso bange bagezaako okusaba Oweekitiibwa omulamuzi okubeera ng'ayisa kooti order okubeera nga tufuna ebiwandiiko by'abadokita okubeera nga tufuna report original report ku ebyo bye byazuula nti twatulugunyizibwa naye kooti eno ey'ekitiibwa yagana okubeera ng'ereeta oda eyo ate nga bwe bujulizi obumu kubwetaagisa mu musango guno okubeera nga nange mbuyimirirako.
With the above reasons, they asked the trial judge Alex Ajij to recuse himself from this case, alleging bias. However, all the prayers were objected by the prosecution, led by Senior State Attorney Joseph Chomuhendo.
My Lord, we object to the accused person's application. We object to the application. For recusal. On the ground that it is frivolous, vexatious, and aimed at borrowing time, by the accused persons, my Lord. Article 28 of the Constitution of the Republic of Uganda 1995 that outlines 28 that outlines the rights of an accused person, that any court or tribunal should comply with, in order to make the trial a fair one. My Lord, we are relying on the article in its entirety, and all the rights encompassed in the article have been observed by the court and the prosecution. By this honorable court and prosecution. My Lord, the accused persons have always got the adjournments that they've prayed for. The accused persons have always got the adjournments that they've prayed for. They are ably represented. They are ably represented by a team of 4 mighty defense lawyers. Even when they filed an application for nullification of this trial on the ground that they were tortured, this honorable court, even when they filed an application for nullification of this trial on an allegation of torture, this honorable court halted the trial and resolved the application. All trials, both criminal and civil, are governed by certain rules. For instance, my Lord, examination in chief and cross-examination are governed by certain rules. And my Lord, there are questions that are allowed and there are questions that cannot be allowed. For instance, my Lord, in cross-examination are not allowed in examination in chief. Questions that call for opinions are not allowed in both cross-examination and examination in chief. Scandalous questions, cross-examination, examination in chief and cross-examination, my Lord. Scandalous questions, my Lord, are not allowed at all times. And my Lord, where any of the above arises, the prosecution or the defense is in order. The prosecution or the defense is in order to raise an objection. The prosecution or defense is in order to raise an objection or objections to such questions. And my Lord, it is up to court to determine. It is up to court to determine whether the question should be asked or not, or whether the question should be answered or not. Whenever such a situation arose. My Lord, on several occasions within this trial, both the prosecution and counsel for the accused persons have raised objections to certain conduct or questions. And the objections have either been sustained or overruled. My Lord, we pray that you dismiss this ground as baseless. Perhaps the accused persons need paralegal education on how to conduct a criminal trial, my Lord. My Lord, the second allegation is that the accused person's allegation of torture has been disregarded. My Lord, it is right law that this honorable court entertains only and only written applications. My Lord, when the accused persons filed their application, hearing of this case was halted as required by law, and the application was heard. My Lord, the trial was halted and the application was heard and dismissed. And my Lord, the decision was explained. The decision was explained to the accused persons. They have not exercised their right to appeal, and they have not taken any other step in regard to those allegations. My Lord, another allegation in regard to the medical documents. The accused persons were examined from a private facility. And whereas they are incarcerated, they have able representatives. Which representatives did not take any effort to write requesting for the original copies. We pray that that ground is also disregarded. But in any case, the application was filed and those very documents attached, and they have not taken any other step.
Chamuhenda also told court that this is a delaying tactic on grounds that all the allegations raised are baseless, with the above he asked court to dismiss the application before it.
My Lord, the accused persons have prayed for recusal. They have prayed for recusal. And our contention is, as prosecution, is that the way the trial is proceeding, it is fair, and there is no ground for recusal. My Lord, I'm relying on the Constitution, I'm relying on the Constitution, in brackets, recusal of judicial officers, open brackets, recusal of judicial officers, close brackets, practice directions of 2019. Or recusal of judicial officers practice directions 2019. My Lord, Rule 5 of the practice directions states that a judicial officer may, on application by any of the parties, on application by any of the parties, or on his or her own behalf motion, or on his or her own motion, recuse himself or herself from any proceedings in which his or her impartiality will reasonably be in question. My Lord, Rule 6 provides for the circumstances for recusal by a judicial officer. Oh, I'm sorry, my Lord, this is for when it's on your own motion. My Lord, I'm citing Rule 7, recusal at instance of parties. My Lord, the rule states that any party to the proceedings may apply to court for a judicial officer to recuse himself or herself under the following circumstances: where the judicial officer has an interest in the subject matter, where the judicial officer has an interest in the subject matter or has a relationship with any person who is interested in the matter. My Lord, the accused persons have not even attempted to. My Lord, B is where a judicial officer has background information or experience, such as the judicial officer's prior work as a lawyer. Has background information or experience, such as the judicial officer's prior work as a lawyer. My Lord, you have never been an investigator, you have never been a state attorney. This does not apply. Where a judicial officer has personal knowledge about the parties, where a judicial officer has personal knowledge about the parties or the facts of the case. Personal knowledge about the parties or the facts of the case. Where a judicial officer, this is D, where a judicial officer has ex parte communications, where a judicial officer has ex parte communications with lawyers or parties to the case. My Lord, we are not aware as the prosecution of any circumstances under which we have met you without our learned friends. E, where a judicial officer makes inappropriate comments, or where a judicial officer makes inappropriate comments or exhibits unacceptable conduct in the course of the hearing. My Lord, I have not heard this allegation in the accused person's application. And lastly, where a judicial officer has exhibited actual or imputed apparent bias, where actual or imputed or apparent bias. My Lord, this has not arisen in this case. My Lord, we are relying on the case of Magara Investments Limited. Magara Investments Limited versus Magara Investments Limited versus the Commissioner General URA. It is civil appeal number 15. It is civil appeal number 15 of 2007. Civil appeal number 15 of 2007. My Lord, I quote the land trial judge. My Lord, I quote Wambuzi, CJ as he then was. To conclude, I must state that there is a growing tendency in these courts. There is a growing tendency in these courts to lay false accusations of bias. Either to avoid certain judicial officers handling their cases, or to cause delay in the disposal of cases. Their grievance should have been resolved using that mechanism. My Lord, in a nutshell, the accused persons have not raised any reasonable ground that would lead to your recusal. My Lord, it suffices to note that whenever a class of certain witnesses stands up in court, it sends panic into the accused persons, my Lord. We pray for dismissal with contempt of this application.
After listening to both sides' submissions, Judge Alex Ajij Makai dismissed the accused's application.
So I now go ahead to give my brief ruling on the prayer for recusal. In the first place, the recusal rules dictate that the party seeking the judicial officer to recuse himself is supposed to see the judicial officer in chambers and raise the matter with the judicial officer. Are you there? Okay. So if the judicial officer refuses to recuse himself, then the matter can be raised in open court. The first step in recusal procedure was therefore missed. Nevertheless, it was important that I listen to the grounds there is recusal, where three grounds were raised, namely, one, that I was not allowing the lawyers of suspects to ask questions and not allowed counsel for the state to ask questions. Two, that upon the application for human rights enforcement, I did not afford them a chance to raise the allegations. Three, that I refused to accord them an order for the NGO to avail them with original documents for use in the application.
Judge Ajij was also of the view that the application lacked grounds to allow him recuse himself in this matter, other than just wasting court's time.
I shall start with the first ground, that I was not allowing counsel on state brief to ask questions. I have this to say. Criminal procedure has it that there is examination in chief, where the counsel of the state leads their witnesses through questions. Thereafter, the counsel on state brief asks the witnesses questions, the witness questions, and thereafter there is re-examination by the counsel of the state. This is the correct and obvious procedure which I have used throughout this trial. That's rightly pointed out by Counsel Tomohendo, Chief Seratone. There are questions which are not allowed. He just scandalous questions, embarrassing questions, etc. And it is the judicial officer to prevail over parties whenever such questions are asked. And so he either allows the questions or refuses the counsel to ask such questions. I must say I have followed this through, and in this allegation, the accused persons are not citing any type of question that refuse to be asked by themselves, or even a situation such as has been said where the above allegations of ground would stand, and for that matter, this ground must fail. The second issue is on the application arising from the
Court also had this to say about the torture allegations raised by the accused in this case.
When they raised and filed the application, at first it was withdrawn by the accused persons themselves, then again refiled. They sought to be heard and to have the trial halted to allow for the hearing of the application. Indeed, I did halt the trial for well over 1 month and directed the parties to file their submissions, upon which I made a ruling in which I dismissed the application on merit. Again, I must say that if the accused persons were aggrieved by my ruling, then they should have appealed against my decision. However, they did not, and even a letter alleged to have been written to the registrar, which never came to my desk, could not be taken as a step in the right direction. They ought to have appealed, but they did not. All in all, the application was heard and dismissed, and so this ground too is baseless. African Center for Treatment and Rehabilitation of Torture Victims to avail the suspects with their original documents. This too was handled at the very time the suspects sought court to make that order. And I was clear that the NGO was a private clinic, and the treatment was therefore from a private facility. And since it was a private affair, court could not order that center to produce the original documents of the suspects. I shall agree with the Chief Seratone that the allegations are frivolous, vexatious, and baseless. And indeed, I cannot avoid thinking that it is an attempt at derailing the hearing of this case. The grounds upon which the judicial officer can recuse himself have been enunciated by the Chief Seratone, and I agree with them as set out in the judicial officer's recusal of judicial officer's practice directions. And indeed, the suspects even managed to get near to any of those grounds. Actually, none of those grounds have been mentioned or proved, if any. And so again, there is no reason for me to accuse myself, as no serious reason has been advanced as to why I should do so. Lastly, it should be noted that this is a very serious matter, a very serious trial, on a very heinous offense, which has now gone 2/3 into the trial, with the 22 witnesses having testified. And for one to seek my recusal from the case is therefore sadism. We are investigating a murder, and at this stage, court has not pronounced itself on these charges, save through the hearing, which is ongoing. I have noted the comments of Wambusi CJ in the case of Mera Investments versus URA, and I respectively agree with them. Justice is two-way. Justice is two-way. Repeat, it cannot be for the accused persons alone. Even the relatives of the person upon which the charges are leveled against the accused persons are equally hurting. And so let us avoid raising flimsy excuses to delay the trial. I took a judicial oath to administer justice to all manner of people without fear or favor, without affection or ill will, and so I am exactly executing my mandate. Let the hearing.
Due to time, Judge Alex Ajij Makai adjourned the case to tomorrow, 11th September 2024. When prosecution will present more witnesses, the 9 accused persons have been further remanded to Ruzula Government Prison.